So our final topic this afternoon is another CRA target audit area, and it relates to the status of an individual of whether or not he or she is an independent contractor or an employee. So if we look at, we're going to go over four areas. The first, why is this issue important? Secondly, we'll talk about some tests and criteria to determine whether a person is an employee or an independent contractor. We'll give some examples and some specific examples that are going to be for our public company clients. And then also we'll discuss what should be in the contracts. So looking at why this is important, right now, again, we've got a current audit focus by CRA on payroll, on whether or not someone is an employee or an independent contractor. And again, they're looking at ways of increasing revenue. So if they deem someone to be an employee and not a contractor, they're getting more CPP, they're getting the employer portion of EI. So it's another way for them to raise revenues. And then on the individual side, they're disallowing expenses that that individual has claimed as a self-employed or a contractor, generally because an employee is restricted on what expenses can be claimed when they are an employee. There's director liability issues, that if there's a failure to withhold CPP, EI, and tax, that directors are liable if an individual is an employee and not an independent contractor. And conversely, if a person is a contractor, there's no requirement to withhold. For stock options, again, we've got an employee receiving stock options. There is a requirement to withhold tax and CPP, but if that person is a contractor, there's no requirement to withhold. And then the other two, I mean, there's employment standards, vacation pay, holiday pay, overtime pay, and the like are related to when someone is an employee versus there's no requirements for a company that is engaging an independent contractor. And finally, common law, employee could be liable for wrongful dismissal with an employee, and there obviously is not that issue for a company if they're hiring consultants. So now I'd like to turn it over to Annelie, and she'll discuss employee versus contractor tests and criteria.
Thank you, Brad. I'm quickly going to discuss some of the tests and criteria that we generally look at and what CRA is also relying on in determining if someone is an independent contractor or employee. The treatment as either an independent contractor or an employee will depend on the facts of each situation. In Canada, the Weep Door case is the leading court case that all of us rely on when determining if an individual is an independent contractor or an employee. And the criteria that the Weep Door case is setting out is, first of all, the degree of control, the ownership of tools, the chance of profit and loss, and the integration into the employer or the company's business. So next we're going to look at a couple of questions that we can ask to determine if an individual status as an independent contractor or an employee. Okay, so when we look at a degree of control, some of the questions that we ask is, who controls the day-to-day activities that is performed by the individual? Would that be the company controlling it? Are they deciding what should be happening every day? Or is that the independent contractor coming in deciding how that's going to work? Where are the services performed? Who is deciding where the services are performed? Is that the company once again? Or would that be the employee or the independent contractor deciding where that is performed? And who does this individual report to? And who determines how the services are actually performed? The second test is the ownership of tools. And generally, an independent contractor will own their own tools. And with tools, we refer to more than just what you would normally think of as tools. We look at computers and cell phone contracts and all that kind of things that business people use as well. So first of all, we look at, does this individual require specific equipment? And if they require equipment, who is actually providing the equipment? Would that be the company providing it, or would that be the individual providing the contract and the tools? Is the individual able to hire an assistant? Can they hire an assistant? If they hire an assistant, who will be paying for the assistant? Would that be the company or the individual? And can they work from a home office or an office outside of the company's business? And I mentioned the cell phone plan once again. Who is actually paying for all of the expenses, the home office, the cell phone, the computer, everything else? If they are being reimbursed, you do have a little bit more of a question. Is this person acting as an employee or independent contractor? So the third test that we're looking at is a chance of profit or a risk of loss. So here we have to ask the question, can this person increase their profits by changing their contract, having more than one contract, and are they able to have more than one contract? Is their contract that they have signed, the documented contract, actually allowing them to have that? Would the individual be paid on a monthly or hourly basis, or are they being paid on a contract basis? And then depending on the outcome of this, if you're on an hourly or monthly payment plan, obviously your risk of having a loss or a profit would be decreased. Whereas if you're on a contract basis and you can finish a contract a lot faster, you can move on to another contract and thereby increasing your chances of a profit. And what happens if the individual, if the work is not completed in time? Is there possible penalties to the independent contractor, or is there not any penalties? The fourth test is integration into the company's business. An independent contractor is not economically dependent on the company and will not be integrated into the company's business, but is merely accessory to it. So a couple of things that we look at here again is there business cards for the individual? The business cards, does it have the logo of the company with the title on it? So that's a couple of things that we look at. And you have to look at all of the tests. Meeting some of the tests, say meeting 3 of the tests, but having one that is outweighing all of the tests that you're meeting could potentially still mean that you could be an independent contractor or an employee in CRA's eyes. So recently a new court case came out, and it's the Holmes case. And in this case, the courts actually clarified the intention of the parties and set out a 2-step test that should be looked at when determining if an individual is an employee or an independent contractor. So first, you have to look at the documented intention of the parties. And with that, we don't just look at the contract, we also look at invoices being issued. Is the individual registered for GST? And how do they report all of the income on their tax return? Are they reporting as an independent contractor, or are they reporting as an employee? And then the second part of the test is going back to the Weep Door case that we just discussed. And you actually go through that and you look at the 4 criteria set out in the Weep Door case and make sure that what is actually happening is supporting the first part of the test, which is the documented part. So we once again look at the control, we look at the tools being used, ownership of tools, we look at the risk of the chance for profit or risk of loss, and integration into the business. So I was thinking we can go through a couple of different examples, and maybe you guys can help me with that. So the first example that we have is Mr. A. Mr. A is providing investor relations services to a public company. Mr. A is registered for GST, and he's providing invoices and charging GST on the services. He is listed on the company's website as one of the contact people, but Mr. A doesn't have any other clients. He's only working for the one company. The intention of both parties are to be an independent contractor relationship. So what will CRA think Mr. A is? Anyone?
Employee.
Why do you say employee?
I would say there's only one company he's working for.
Mm-hmm.
Doing all his work in their office,
Mm-hmm.
listed on the company website,
Mm-hmm.
so he's an employee.
Yep. And most likely CRA will agree with you that Mr. A is in fact an employee. So even if we look at the intention of the parties, so our first step in the Connor Holmes case was to look at the intention. The intention was clear. They wanted to be an independent contractor. But like you mentioned, when we look at the 4 tests set out in the WEEP case, the degree of control, the tools being used, he used the company's tools, he was in the office, but he controlled his own hours. So then again, it's a little bit neutral on the degree of control. Chance of profit and loss, he was paid on an hourly rate, so there's no real risk of a profit or loss there. He's getting paid even if the work's not done. And then on the integration, he's a contact person of the company. So if you look at all of the factors together, it is pointing towards an employee. So let's look at example number 2. In example number 2, we've got Mr. B, and he's providing contract CFO services. Once again, he's just providing the services to one company. But Mr. C is actually providing the services in his home office as well as the office of the company. The intention, once again, is to be treated as an independent contractor. And he is able to participate in the stock option plan for the employees. And Mr. B is also registered for GST and is charging GST on his services. So, any idea what CRA would think Mr. B is? And why would you say he's an employee?
No other clients, or substantially all from one client.
Yep. You're right. CRA would most likely think that Mr. B is an employee. Similar to the previous situation, Mr. B, even though the intention was there to be an independent contractor, Mr. B is only providing services to one company. Even though he can control his hours and where the services are being performed, he's still using the company's tools, and he still doesn't have a chance of a profit or loss, and he is integrated into the company, being one of the contact people. So if we look at all of the facts once again, we are back at being an employee. So the last example that I have is for Mr. C. Mr. C is also providing public company services to a public company as a contract CFO. Mr. C, however, is providing CFO services to many different companies. He's registered for GST, but he's providing his services through a company, and that company is charging GST to the company that he's performing the services to. He's providing his own computer and his own cell phone, and but he's using the company software. And the intention of all the parties are to be treated as an independent contractor. So what would Mr. C be?
Contractor. Where's the contract?
Mm-hmm. And why would you say he's a contractor?
Well, he's using his own equipment
Mm-hmm.
for multiple companies. He's
Mhm.
working out of his own home. He's paying everything himself.
Mm-hmm.
So, he's not relying on one group.
Yeah, exactly. So CRI would most likely conclude that Mr. C is an independent contractor. Using the Connor Holmes case, the intention was there to be an independent contractor from the beginning, from both parties. The degree of control, Mr. C is controlling the hours worked, how the work was completed, and where the work was completed. If we look at the tools, he's using his own computer, his own cell phone that he's paying for. So even though he's using the software, that's just a minor, small amount. The chance of profit and loss, even though he's paid at an hourly rate, he's still the one paying all of his corporate expenses. So there is some risk of a loss there or a profit. And then the integration, he's a contact person, so that's the only factor that's a little bit pointing towards employee. But if you look at everything as a whole, Mr. C would most likely be an independent contractor. So next, we're going to look at a couple of things regarding contracts. We're not lawyers, so bear with us. I'm just going to point out a couple of things. I'm not going to go through slides in detail, so if you've got any questions, any specific questions, we can talk about it afterwards. So contracts could be an amazing evidence of what the intent of the relationship would be. If the contracts are worded correctly, it can limit a whole bunch of stuff. It can limit the termination damages without cause and breach of contract. It can limit the amount of the minimum notice required on the Employment Standards Code. And the biggest thing for the companies, if the contract is worded correctly, it could potentially indemnify the company if the CRA comes back and recharacterize the relationship between the individual and the company. And there's potential withholdings or CPP and EI. So a couple of provisions that could potentially help minimize the risk of an independent contractor being found an employee is to expressly put it in the contract that the intention of the parties are to be that of an independent contractor. You have to put it in there. It's amazing how many contracts we look at that it's nowhere mentioned in the contract, and you go through the contract and at the end of the day you're like, I am not quite sure where we want it to be with this contract. So if it's one of the first things put in there, it's the intention of the parties that Mr. A or Mr. B is an independent contractor. That's going to go a long way already. The second thing is, don't use terms like Mr. B's position or his duties or the work to be performed or anything like that that could potentially be seen as terms relating to employees. Try and limit the duration of the contract. Have a 3-month or 6-month contract. Don't have a contract that just goes on forever, because that kind of looks like an employment contract again. And avoid sort of controlling the time and the work, and allow the individual to be able to look for other contracts. In the contract, specifically require invoices to be rendered before the person actually gets paid. And sparingly use the non-compete clauses because you want to make sure that this individual have the ability to meet all of the criteria set out in the WEEB test, of which one is their ability to get a profit and loss. So you want to make sure that they have that ability to get that profit. And if it is by getting multiple contracts, your contract should not be limiting them. And then, if possible, require them to use their own tools, get their own cell phones, if possible, get their own laptops, or any other tools possible. I talked a little bit about the indemnity clauses. I would encourage having something in your contracts with independent contractors, especially because if CRA comes back and recharacterize the relationship, the withholding taxes, the CPP and the EI, plus the penalties and interest could be substantial, especially if you've got a whole bunch of people that get their relationship gets changed. Termination, we've talked about that a little bit. Make sure that you have something in there. Determine beforehand how the contract gets terminated. And that will just be more proof of it being an independent contractor and not an employee. And then some general advice. If you're looking at the contract, have the other individual signing the contract actually get their own legal advice. If they have their own legal advice, that's a little bit more evidence that they are an independent contractor and they're not merely signing an employment contract. I already mentioned the non-competition clauses. That should not be used if possible. if it's possible not to use that, especially since a lot of our companies are smaller and the only way that someone's going to make a profit is working for a whole bunch of different companies, that should not be used. And then we've talked about sort of avoiding certain terms. So a couple of things that we notice in contracts that could be very confusing to the CRA, especially if you're trying to be an independent contractor, is stuff like vacation pay. I mean, generally, if you think about an independent contractor, they don't get vacation pay, but an employee would get vacation pay. Set work hours, requiring the individual to be in the office between 8 and 5. That should be avoided. Overtime compensation, once again, that is something that goes back to being an employee. Employees generally get paid overtime. Minimum hours in the office. By limiting by sort of setting the hours that they have in the office, you could potentially be limiting their hours to get a different contract. And, I'm not sure what the use of we should have in there that they use their own tools. So just to recap sort of everything that I've been talking about is, first of all, make sure that when the two parties meet, when you're setting up this arrangement of getting the individual in to perform the services, sit down and make sure that both parties are on the same page about the relationship. Is it the intention of both parties to be independent contractor, or do you want this person to be an employee? Make sure that you have that intention right at the beginning. Second thing is, once you agree on the intention, document it. Go ahead and get a contract. Put it right in the contract, what the intention is of the parties. Put in there the indemnification for in case CRA comes back and they change it to be an employee. And then look at the terms as we said to avoid. Don't put in there as employee, don't put in their titles, don't put in their hours or overtime or something like that. And then last of all, once everything is done, every couple of months or once a year or so, go through the criteria set up by the WEEP case and make sure that the reality is still supporting what the contract is saying. Look at who's controlling everything, who's providing the tools, is there a chance of a profit and loss, and look at the integration into the company's business.